Good morning, ladies and gentlemen, and welcome to the second plenary today. I'd like to start this plenary by taking the opportunity to pay respects to and celebrate the life of Jose Luis Martin Chito Gascon, Chair of the Philippines Commission on Human Rights, who very sadly and prematurely passed away over the weekend due to COVID. He was a true champion of human rights in every sense of the word, and faced many personal threats to his own safety and liberty, and was a champion of digital technologies as well. A few of us in this room have had the privilege and honour of working with him, and he will be sorely missed by his Commission colleagues and the human rights community in general. He would have really appreciated this conversation here today, I'm sure. He oversaw a number of initiatives at the Commission in terms of digital transformation, and would have been very interested, I'm sure, to take part in this discussion. So just to begin with, I'd like to honour and pay respects to Chair Chito. Thank you. So as we turn to the topic at hand, it's worth reflecting on how we've got to this point in time. So over the past few decades, we've achieved great success in terms of standard setting, the passage of new conventions, the establishment of national human rights institutions, the institution of the Universal Periodic Review, and all of the standard setting that comes with that. But have we achieved equal success when it comes to our methods of implementation, the resources that are allocated towards implementation? Arguably not. So it's really important to consider what the consequences of that are. And if we look at the amount of overdue reports at the moment, there seems to be a real cause for concern. But of course, overdue reports are only a symptom of a wider problem. And that is the lack of a coordinated approach to implementation and tracking of our progress, and the changed reality of people on the ground. So the size of the audience that we have online today, and I see there's around 100 people online, and it's fantastic to see so many people in the room, demonstrates that there's a real appetite and potential around this digital transformation that we're here to discuss today. So it's therefore a great pleasure and privilege to be here moderating in front of you all today. My name is Ash, and normally I'm based in Fiji, where I work for the Pacific community. So we're an intergovernmental organisation who provides technical assistance to our 26 member states on, amongst other things, they're implementing their human rights obligations. And I've been based there for the best part of a decade. And our members are some of the smallest in terms of populations, in terms of resource challenges, and they're really at the coalface when it comes to this reporting burden. So I think they have a lot of lessons that we can hopefully share today. And what we've seen over the past decade is a real appetite for change, for using digital tools to help with implementation and reporting. But possibly that hasn't quite been met with what's on offer. So it's really important and for us all to be here today to share our lessons and to see how we can chart a way forward. So I think it's also important to recognise that we shouldn't be under any illusions. We're quite far behind when it comes to the digital transformation in the human rights sector. The private sector is way ahead of the game in terms of this, but what that does is it offers us an opportunity. Offers us an opportunity to learn from other sectors, to learn from one another, and when we're undergoing this digital transformation, not to make mistakes. And I'd like to acknowledge the convening of this plenary here today and the vision of the Geneva Platform for Human Rights, because they've not looked at one specific topic. What we're going to be talking about in this plenary is a range of tools, a range of strategies. So what we'd like to do in this discussion today is try to extract some of the common threads, some of the common challenges, pitfalls, but ways forward that really chart success in terms of strengthening our implementation, monitoring and reporting. What we found is that there's some really important things that we need to try to focus on. What are the factors behind success or failure when it comes to digital transformation? How many tools in one particular space is really valuable? What's the value of open source technology versus off-the-shelf solutions? And how can digital tools break down silos of implementation, and what are the conditions necessary to achieve that and enable the participation of civil society and other implementing actors as well? So in this plenary, please put your minds to exploring these topics, and hopefully by the end of it, we will have some agreement on what are the common threads, and we'll give you some impetus behind playing your own part in this digital shift. So a few house rules just before I introduce the panel, just to reiterate the Felix's house rules from before. In the room, when we come to the Q&A, if you would like to make an intervention, please raise your hand in the traditional sense. If you're online, you also have the opportunity to raise your hand, or you can make comments in the chat box. Please also feel free to share any resources that you feel would be helpful. And if you would like to make any presentations when you're making an intervention, please just let the moderators know, and they will help to facilitate that as well. We are recording this, but this won't be shared publicly without everyone's authorization. So without further ado, it's a great pleasure to introduce our panel. And first up, we have Peggy Hicks, Director of Thematic Engagement of Special Procedures and Right to Development Division of the Office of the High Commissioner for Human Rights. Peggy will be talking to us about the digital shift within the OHCHR and the role of technology in fulfilling the mandate of the office. And OHCHR already has some fantastic flagship products that are making an impact on the ground in the field, with the Universal Human Rights Index and the National Recommendations Tracking Database. So we look forward to hearing what's in the pipeline and your successes so far. Peggy, over to you.
Thanks very much, Ash. And I do think you win the award for coming the furthest. And we don't have that many visitors these days. So it's great to see you. Thanks to the Geneva Academy for convening this important discussion, and really glad to be here. Many of you who know me know that I engage on a lot of discussions around digital technologies and do that with the immense support of our team on these issues. And I wanted to give a shout out to them at the beginning, simply because, especially when we talk more about these application-oriented things, they're the true experts, and I pull together the big pieces. So George Hodge in our office has been very influential on this, Tim Engelhardt, Marcelo Dar, and I see Adrienne Essler is in the room here as well, and probably many others that I'm not aware of, but they're the people who can really give you the details on some of the things that we'll talk about today. So, you know, we often start off this conversation around digital technologies by always acknowledging, and it's a truism now, that, you know, digital technologies are opportunities, but they're also challenges. And then how we actually address both sides of it is for our office, you know, always a question, right? That we want to move, and as Ash has said, we recognize that not just our office, not just the human rights sector in general, but our office, that we're behind on this, and that we have got ground to catch up in terms of how we use digital transformation to advance human rights globally. But at the same time, you know, we're behind. We want to go at speed, but we're not going to adopt Facebook's model of move fast and break things just because we know that, you know, we need to catch up. We need to be very careful about how we deploy new technologies and their influence and potential use, and the potential impacts on human rights. We look in particular about the use of digital technologies in documenting human rights violations and investigations. Those are areas that aren't new, of course, but it's definitely growing and changing for some of the reasons that I'll describe. We see that new technologies in particular, I want to emphasize, are leading to an exponential increase in the volume and types of data that are available to do human rights work. And I think we're really only just starting to recognize that and figure out how we leverage that data to make impact within human rights. And of course, this conversation is about how we bring that to the national level, but I think we're still doing a lot of work at the global and regional levels as well to figure some of those things out. But to some extent, you could say that we're living in a golden age for open source human rights monitoring and investigations, given that level of data that's there and potentially accessible if we can figure out how to use it in a manner that enhances credibility and effectiveness. In recent years, we've seen, for example, that satellite imagery, social media, the Internet of Things, and other digital tools have really opened up new channels for documenting information on human rights violations. It provides the human rights ecosystem with a new wealth of that digital data and imagery, which bolsters the traditional on-the-ground monitoring investigations. The challenge, as I said, is how we harness it in the best way for human rights accountability. How do we make sure, first and foremost, that the digital information that we use and collect is credible and reliable? how do we address potential biases in data? What are the limits of digital technology, in particular, how they work within restrictive environments and how that affects the digital data that we obtain? UN human rights, as Ashley has mentioned, have really developed some human rights investigative methodologies involving all the different ways that we do investigations across our work for decades now, where we look at source assessment and protection, corroboration, verification, analysis, and the standard of proof. And those are tools that are continually improved and enhanced. The challenge, of course, is to figure out how we use those same tools and that digital materials are subjected to the same level of methodological rigor that we've used in human rights investigations and monitoring more generally. The aim that we have throughout has been to ensure that international investigative standards are applied effectively in the digital realm, despite the speed at which the technology is itself evolving. And we seek to highlight the ways, of course, in which digital tools themselves can enhance and boost the credibility of traditional methods of human rights monitoring and investigation. Digital imagery in particular has made and supported conclusions in all sorts of ways within investigations on torture, summary executions, enforced disappearances, arbitrary detention, war crimes, and crimes against humanity. Just 3 examples of how our office has used the tools. In Myanmar, the fact-finding mission there used satellite imagery to corroborate the horrendous accounts of victims, including, of course, leading to findings of crimes against humanity, a case now being adjudicated at the ICJ. In Syria, our office scrutinized videos, many released by the perpetrators themselves, to try to address the graphic abuses and executions there. And the Commission for Human Rights in South Sudan has used satellite imagery to find destruction of property, private property that was widespread, including attacks on civilian populations occurring in 40 villages over a 2-month period, again, leading to a finding that crimes against humanity had likely occurred. We've also, in terms of how we've looked at this space and how we can engage in it, spent a considerable amount of effort working with the Berkeley Human Rights Center to develop and publish a protocol on digital open source investigations. And we hope that that tool will be a critical device that can be used within this space to counter mis and disinformation. The protocol sets forth the principles and methods behind verification and authentication, trying to do that in a way that both practitioners and lay people can understand. It places protection and security at the forefront. We try to operationalize the do no harm principle as applied in the digital sphere. And it identifies some of the core technical resources and expertise needed for these investigations. The foundation within that protocol, of course, is the ethical, professional, methodological, and legal principles about how information is collected in line with human rights standards, including, for example, the rights of privacy and due process. And then once we ground our investigations in those principles, to ensure then that the data that's information that's collected is done so in a way that allows it to be used in all the different ways we want to use it within the human rights ecosystem, be it in trials and transitional justice mechanisms, by commissions of inquiry, or other opportunities. In the earlier panel, which I had the chance to catch the end of, I know that we talked a bit about how we can do more as the United Nations to connect some of the work that's being done to national institutions and approaches. And, you know, obviously with the idea that what happens in Geneva or New York shouldn't stay there. We need to figure out how we give the support necessary at the national and local level to be able to engage in these conversations most effectively. And I wanted to highlight 2 ways in which our office has focused on doing this, connecting national human rights actors with human rights mechanisms. The first is a tool that I hope is familiar to many of you, which is the Universal Human Rights Index. It's a public database that contains all the country-specific recommendations issued by special procedures, treaty bodies, and Universal Periodic Review. But we've taken that a big step further by tagging the Sustainable Development Goals and groups of affected persons within it, among other variables. So the links are there and highlight the synergies between human rights and the sustainable development agenda. And it really gives us all a greater way to access some of this information and apply it within our work, we hope. The data is freely accessible and available in a variety of formats for stakeholders, including in spreadsheets or application programming interface APIs to feed ongoing monitoring and follow-up. The second tool is one that I know was discussed briefly in the earlier panel, which is the National Recommendations Tracking Database, Nrtd. It's connected to the Universal Human Rights Index that I mentioned, and it's a digital tool developed for states and national governments to facilitate how they follow up on and report against their their human rights recommendations. It clusters those recommendations, it supports planning of follow-up activities, it tracks implementation and facilitates reporting. And it's been rolled out so far in about 10 states in the last 2 years, and we're revamping it right now and intending to relaunch the updated version in spring of 2022. So digital tools such as these really do address some of the challenges we hear from national states about what they need to do the hard work that Ashley has referenced, including how they address problems like institutional memory due to staff turnover, clarity regarding the reporting recommendations and deadlines associated with them, having a clear record of agreed responsibilities and keeping track of progress via updates and indicators. We also have to keep in mind, of course, that the tool is only as good as those that are using it. So we need to make sure that we also look at the ways and at the national level that there is a political commitment of governments to coordinate and to use these tools effectively. We're going to have upcoming regional conversations and consultations on these national mechanisms for implementation, reporting, and follow-up. And just wanted to mention that there's more detail on those on our website. In closing, I just want to go back to that opening theme of the challenges and opportunities. We know, of course, then that digital technology is a coin with two sides. The same tools and data that can be used to strengthen human rights investigation and reporting are also a serious threat to human rights defenders and civil society more generally. We've seen the consequences, for example, recently of surveillance technology being deployed against journalists, human rights activists, and political figures in the Pegasus scandal. The High Commissioner has herself called for a moratorium on the use of that surveillance technology by governments and the sale and transfer of it until compliance with human rights standards can be guaranteed. Those threats, I think, make it all the more important to have conversations like this one about how we embed human rights standards into the technologies that are being designed, developed, and deployed. We need to do that with both states and companies, and to emphasize within those conversations the importance of human rights due diligence and how we encourage through regulatory measures both transparency and accountability for the use of digital technologies. We also, when we're looking to the future, see these issues around data and how data is used, how it's stored, how it's protected, and how we access it and search for things within it as one of the key areas. We're working, for example, and have relied on Monash University and Access Now's work relating to internet shutdowns, where they look at internet connectivity data. It's like looking for a needle in a haystack, but if you know how to do it and have the right algorithms and approaches, you're able to really bring data to bear on some of the great human rights challenges like internet shutdowns. So kudos to that work and looking for all the ways that we can have more partnerships like that one. It is a brave new world for digital technologies in human rights, and just to emphasize that we all have a role to play in ensuring that we get the most out of these technologies while making sure that those negative impacts don't overwhelm the work that we're doing. Thanks.
Thanks so much, Peggy. And I think you've highlighted some fantastic points there in terms of the benefits of these technologies, but also very importantly, some of the principles that we need to be really conscious of when we're developing these, not least the do no harm principle, and also for us to be very aware of the limitations of these technologies. The technology is not a panacea for human rights implementation, reporting and tracking. And I think the point that you made about data only being as good as what people put in is what you can get out as well. There's been a number of conversations in the Pacific where we've engaged with our member states on software like the National Recommendations Tracking Database, Samore, Impact OSS. And there's a conception that we install this software and then that's it. We don't have to worry about reporting anymore. We press a button, it does the state report, that's job done. That's not the case. So there's very much an element of managing expectations when it comes to technology. And the point you made about the integrated approach to the SDGs and human rights and the value in that is a really important one as well. And I think we might hear more about that from our next speaker, Maria Alejandro Costa Prieta, Deputy Permanent Representative from the Permanent Mission of Uruguay to the United Nations in Geneva, Ministry of Foreign Affairs of Uruguay. Alejandra will be speaking to us about Samore, which is the longest standing tracking and reporting tool in existence, as far as I'm aware, that's open source. So Alejandra, thank you so much for being with us today. It would be great to hear your experiences of using Samore, and in particular, what's been the impact and what would you say have been the main successes and challenges in its implementation? Alejandro, the floor is yours.
Thank you, Ashley. Thank you, everyone. Let me first thank the Geneva Academy for the invitation and tell you I'm delighted to be part of this annual conference of the Geneva Human Rights Platform. I would really like to be there with you in person, but I was already engaged in other events today, so I'm kind of taking advantage of the digital shift we've been witnessing and using these last couple of years. So let's get to the point. The implementation of the national mechanism for the preparation of reports and recommendation follow-up, Samore in short, was a huge step forward for Uruguay. Briefly, our national mechanism consists of, and you'll see that the digital tool is the heart of our Samore. Uruguay adopted Samore in 2016 in response mostly to the need of institutionalizing and organizing more efficiently the preparation of national reports to treaty bodies, special procedures, and even UPR. Samore means recommendation monitoring system and involves the software itself, a network of focal points from all the national institutions, including the parliament, the judiciary, and even local governments. And the third part is, or are the thematic working groups where the focal points meet and responsibilities are distributed. As I told you, the digital part is the heart of the mechanism, and we like to say that the working groups are actually the soul of the mechanism. The creation and implementation of Uruguay's national mechanism was a process in itself, which I'll skip for time's sake, but it was an important part in having the first approach to a real interinstitutional involvement with the universal system for the protection of human rights. And for that, the digital part, the software itself, was the key element. But as I was saying, Samore meant to standardize and have all the recommendations received and accepted by Uruguay in one accessible place. Literally, it was going from, it was going from digging out all papers to just clicking a couple of times on a web page. It was a huge difference, and you'll see later. Being able to access and follow up the implementation of recommendations in an easy, clear, and transparent way has allowed the universal mechanisms and special procedures themselves, as well as other countries, to have a clear view of how the country, in this case Uruguay, is implementing its accepted obligations. Also, it brought the universal system much closer to the national authorities. And I highlight here authorities whose everyday work deals with very tangible and short-term national issues and are not usually very familiar with how the universal human rights system works. Again, The digital tool here play a key role. It also made the national institutions become really involved in the country international commitments and therefore understand the need to implement the recommendations. And fourth, somehow it helped also civil society and especially the small civil society organizations to fulfill their surveillance role, if you allow me the word, since the information on the government's view on human rights recommendations are now easier to access. Even more, that view, the government's view on if the recommendation is implemented, it is not, it is in progress or whatever, has been officially validated and assumed by one or more national institutions. And those are just a few examples of what the use of the digital tools meant for my country and probably for most of the country. Before CIMORE, I would not lie if I say that the Ministry of Foreign Affairs had to start from scratch every time we had a report to prepare, a visit to receive, or even an oral presentation to UPR or to a treaty body to make. Truth be told, we had to start something of an educational process, if you want, with the relevant institutions and convince the authorities that one of its officials needed to join us to prepare that report or presentation. Usually, you can imagine, neither the authority nor the official was happy that we added one more task to their everyday work. CIMORE led the institution to be involved from the beginning and all through the process of follow-up and implementation. Again, I stress here the word institution. Officials within the institutions may change, but with CIMORE, the institution got involved. CIMORE empowered the institution somehow. It doesn't matter if the person that was involved, say in the preparation of the report or the oral presentation to a treaty body, and therefore knew what we were talking about, is the same person later when the recommendation or recommendations must be implemented. The decree that created CIMORE states that every institution should designate a focal point by the highest authority, most of the cases the minister itself. And that person is responsible not only for making the follow-up of the recommendations, but for having this responsibility permeate within the institution. So that focal point can change, but establish and formal process of having on the long term someone appointed has created an institutional conscience. The degree of implementation of every recommendation, sorry, I got lost here. The degree of implementation of every recommendation that is uploaded in CIMORE was agreed, signed, confirmed, and assumed by the institution or institutions that have the responsibility of implementing them. CIMORE, again, helped create institutional belonging. So the digital shift, and to sum up a little bit, the digital shift that my country experienced in terms of a comprehensive human rights recommendations monitoring and implementation through CIMORE has been substantive and well received by all the stakeholders. Actually, our last batch of treaty bodies reporting, as well as the voluntary midterm UPR report, were successfully prepared thanks to CIMORE, and in this last case, the midterm report, it was done during the pandemic. So what's more important is that the recommendation follow-up and implementation degree was available to all those stakeholders to play their part in making at the end the human rights promotion and protection work at the national and the international level. So I leave it here, Ashley, and I'm of course more than willing to answer questions whenever you say. Thank you very much.
Thanks so much, Alejandra. That was such an articulate expression of the before and after. So before CIMORE, it was this ad hoc reporting approach that we're all very familiar with. with the end result being that the engagement with the international system is minimal, the impact on implementation is minimal. And as a result of Samore, that's been transformed. So the focus is now on implementation. It enables participation with civil society, it increases accountability. And the key word there is it enables. It doesn't guarantee the success. It still requires the real engagement of people like Alejandra and all of her colleagues. But Samore has enabled that flip in focus from ad hoc reporting to implementation. And so that just shows the power of these digital tools. So thank you so much for that, Alejandra. And moving on to our next speaker, who will be able to provide hopefully similar insights in Pakistan, Salman Asif, Senior Human Rights and Social Protection Expert for the Decentralization, Human Rights and Local Governance and Democratic Governance Unit of the United Nations Development Programme in Pakistan. Salman will be giving us an insight into UNDP's tool there, the Human Rights Information Management System. So Salman, it would be great to hear some more about your experiences there and how the management system, the information management system, has been able to break down those silos of implementation and transform ad hoc reporting into implementation. Thank you, Salman, over to you.
Thank you, Ashley. Just to give a very quick context, but also to say that how very grateful we are to Geneva Human Rights Platform for making us part of this timely, inclusive exchange. So in terms of the background, the Islamic Republic of Pakistan, would you just give me 1 second? Let me just put this phone connection off. The Islamic Republic of Pakistan is a signatory to several international rights, human rights and treaty conventions. And despite its complex human rights ecosystem resonant with consecutive treaty body observations, civil society concerns regarding spaces for civil, political, and cultural liberties, Pakistan is also a member of the Human Rights Council and indeed one of its founding members. In 2014, the European Union granted Pakistan the GSP Plus status, providing tariff preferences conditioned on the ratification and effective implementation of the 27 core international conventions on human and labor rights, environmental protection, and good governance. Pakistan has also prioritized SDGs as its national human development framework. The critical point arrived in 2010 when the National Parliament of Pakistan unanimously adopted the 18th constitutional amendment, turning the country into a federation and providing the 4 provinces with strong legislative and financial autonomy. And that also created a very complex social development environment, given while provincial autonomy turned the country into a true federation, but there continues to be very many issues of capacity and coordination between the center and the provinces, limiting the federating units, i.e. the provinces, in discharging their responsibilities, specifically in the case of institutionalizing Pakistan's human rights commitments, delivering and reporting on them. Since 2017, UNDP, Pakistan's Decentralization, Human Rights and Local Governance, DHL project, has been at the center stage of the digital shift and advocating the role of new technologies towards comprehensive human rights data collection, monitoring, and implementation at the national and provincial levels of Pakistan. And it's through its interprovincial mechanism and close collaboration with the Federal Ministry of Human Rights, the National Human Rights Institutions, that the DHL project's consistent advocacy and capacity building training on human rights data collection and reporting. And we collaborated with UNOHCHR in that regard, that collaboratively, UNDP, OHCHR, the Federal Ministry of Human Rights, provincial governments, through inputs from the civil society, developed the innovative initiative, the HRIMS, Human Rights Information Management System, to enable Pakistan to undertake its responsibilities with regards to rights-based reporting. Some of the key challenges that the human rights management system responds to, three key challenges. Number one, overall capacity gaps amongst the government units in normative understanding of national and international human rights commitments, but equally lack of understanding and capacity in compiling treaty body reports, universal periodic review, and collecting human rights data against 17 human rights indicators from 5 SDGs that have been prioritized by the government of Pakistan. Number two, over-reliance, and one could even say chronic reliance on largely asymmetric, fragmented, unwarranted, and unverifiable manual data collection mechanism, often carried out in the silos. And last but not the least, lack of data verification. So in that regard, the HRIMS data collection, analysis, and reporting mechanism, now with the Federal Ministry of Human Rights and also handed over to the provincial governments, it enshrines concluding observations and recommendations from the treaty bodies, and the recommendations following UPR submissions, and Pakistan is now preparing itself for the 4th cycle of UPR, the SDGs targets and indicators, and all of this in Pakistan's context has led to deliberations and discussions on national human rights indicators, the NMRF mechanism, which is through this process, and the advocacy within this process has been institutionalized by the government of Pakistan, leading up to the Nrtd, and in Pakistan's case, Nrtd plus deliberations. So to sum it up, in this context, UNDP adopted a consultative, inclusive, and evidence-based practical approach premised on the principle of leave no one behind, to integrate human rights approach in national policies and practices, the outcome of which is now gradually becoming visible, and I could give some examples later on. This means putting digital technology at the service of equality and non-discrimination, including in the areas of economic, social, and cultural rights, by enabling modeling, prediction through technologies such as HRIMS. Another aspect of UNDP's collaboration with UNOHCHR, which, as we know, in Pakistan's context is a non-resident entity, has meant bridging OHCHR's association with the government of Pakistan through a spectrum of capacity building workshops led and carried out by OHCHR in Pakistan, orientations, training activities, to a stage where OHCHR is routinely invited by the government of Pakistan, and their technical expertise is leveraged upon by the government of Pakistan periodically. In that sense, the HRIMS process has really led not only UNDP Pakistan undertaking United Nations' fundamental role of being a technical expertise provider or advisor, but also a convener, mediator, as it were, and connecting the dots, and an advocate. Furthermore, in terms of UNDP Pakistan's focus on multi-stakeholder approaches, it has led to ensuring a multi-dimensional approach beyond multi-stakeholdership and multi-stakeholder approach, which is again premised on building trust within the system. And in this case, it means building trust between the federal government and the provincial governments. which very often the twain shall not speak regularly or have the kind of trust capital that the federating units ought to have. And beyond that, bridging the gulf or the schism between the provincial governments and the civil society organizations, in particular rights-based organizations, women's rights groups, women's movement in Pakistan, the human rights defenders, so on and so forth. So what does that mean? That means obliging state machineries, transparency in decision-making, creating foundations for a reliable, well-trained system of, if you like, spotters, fact-checkers, and ensuring oversight, which is consistent and has sustainable anchoring within the mechanisms that are established in the government. That has led to a current project that UNDP has undertaken with the guidance from OHCHR and UNDP's regional headquarters, in collaboration with the Federal Ministry of Human Rights, 15 provincial line departments, national human rights institutions and civil society and private sector, leading to development of a national framework for coherence of national human rights data collection. There are two key objectives. The first one is system coherence and integration across the SDGs framework, human rights data collection and reporting mechanisms. And the second crucial objective and the outcome of this initiative is capacitating and building linkages between rights-based data platforms across the 4 provinces in Pakistan, bearing in mind that some departments have developed what they in Pakistan refer to as human rights data dashboards. And the key challenge has been that many of these platforms, as I pointed out, have been working in silos. So bringing, if you like, harmonization amongst them. Some final key reflections. The importance of evidence, as we all know, is central to defending human rights. Adoption of technology in Pakistan's context has led to a shift from an environment where government units and departments struggled to collect even small amounts of human rights information, to an environment today where often large, nuanced and complex amounts of data can be systemically and efficiently collected. Second reflection, and I would resonate with Peggy and Ashley, both of you highlighted that technology is not a panacea. Technology is not a self-organizing platform. It does not cause change by itself unless it is intimately connected with effective, diligent, vigilant use of information, premised on leave no one behind and do no harm principles, amplifying people's voices, ensuring visibility of their priorities, and ultimately connecting stakeholders to ensure and enhance their agency. And lastly, the goal is not to make the tool itself really, but to make human rights mechanisms and safeguards more effective over time and be accountable and to empower right holders to hold systems accountable on it. The Pakistan, as I pointed out, is at the state level preparing for its 4th UPR cycle and submission, and the deadline is October next year. And we are informed by the Federal Ministry of Human Rights that through consultative processes with the civil society organizations, with the 4 provinces, they are looking forward for Pakistan's UPR submission to be an outcome of the Human Rights Information Management System, the NMRF, and deliberations leading to the Nrtd. Thank you, and over to you.
Thank you, Sam. And again, there's some really interesting and valuable points in there around process and outcomes. In terms of process, I think you touched upon one of the key elements of digital shift, and that's having your users and your stakeholders at the heart of any development and design of these tools. Without their engagement from the start and throughout that process, they're doomed to failure. And I think that you highlighted that very neatly. In terms of outcomes, you also highlighted that these tools can enable a standardized approach to data validation and quality control that can in turn address one of the concerns that was raised earlier around the relationships between government and civil society, that trust it can build up. So thank you so much for those for your intervention, and we look forward to questions to you as well. So moving on to our final panelist, back in the room again, Jonas Grimmeden, Head of Fundamental Rights at Frontex. Jonas will be talking about how fundamental rights is monitoring the enjoyment of rights and what the EU is currently doing in this space. So this is going to be a great opportunity to understand how the UN, how the international human rights system and national actors can learn from the EU, and hopefully vice versa as well. So Jonas, over to you.
Thank you very much, Ash. Pleasure to be here. Maybe I should say the European Union is, as you know, an organization with 27 member states, and Frontex is one of the many agencies in the European Union tasked with border management and coast guard management, or coast guard related management. I would like to start by taking us back to where Sima Samar brought us this morning in her keynote on the UDHR, on the Universal Declaration of Human Rights. At that time, if you look at photos from the time, they had microphones, and that was the technology of the time. When they started the preparatory work in 1946, 47, 48, microphones were very advanced for the time, and they were very far ahead with using that technology. So if we think back, we've come quite a far way from using microphones only, looking at how people log in here. And Ash was mentioning the high number of participants from all over the world, very impressive. If we think of the human rights treaties and the development of human rights treaties, computers were used around the time of the adoption of the CRC, the Convention on Rights of the Child, in 1989. At that time, at the time of the World Conference on Human Rights in 1993, I've read that they started to try out a small intranet in Vienna during the conference to try to communicate using internet of some sort that they brought from New York for the occasion. And a few years later, the United Nations got its first website. So just reflecting on how things have developed. And on a personal note, I remember a teacher I had studying human rights who was from the Office of the High Commission of Human Rights. I don't remember everything he said, but I do remember that he wrote on I guess it was already a whiteboard at the time, he wrote the website of the Office of the High Commissioner, and at that time it was, I believe, ohchr.ch. And that was probably in 1996, so 25 years ago. And then it was a very, very new website. So again, since then, much has happened, obviously, and the human rights world has evolved with it. I would like to do three things, three dimensions to talk about tech and human rights, and starting by interoperability on how existing international human rights monitoring mechanisms are to some extent interoperable, and I'll give a concrete example there. I'd like to highlight more briefly the issue of sort of crowdsourcing and participatory monitoring, and then finally, thirdly, talk about the greater usage of non-human rights specific IT tools, something that Peggy also touched on. So on interoperability of existing international human rights monitoring mechanism, the first of the 3 points. So in my experience, since learning about the website of the Office of the High Commission of Human Rights back in 1996, so a quarter of a century, I realize I'm getting old, is that the monitoring bodies needs to make better use of each other's findings and having more cross-references, reinforcing the messages, reducing the complexity. We've heard this morning from a number of actors how they struggle with all the recommendations and how they try to deal with that. And of course, if we would cross-reference and reinforce messages rather than adopt competing ones or contradictory ones, that would be so much better. And of course, such collaboration is greatly facilitated by IT systems and interoperability of IT systems. And in the European Union, I worked for some years, and I had, for instance, a nice advisory panel consisting of Friedhelm here from Eurodocs and Adrian, who was then working for the Danish Institute, advising me. And we developed a nice tool that is called the European Union Fundamental Rights Information System. This is based at an agency in Vienna where I used to work, so I cannot take any credit for how it has developed, but it's nice that if there are any problems that you spot, it's not me to be blamed any longer. But if you want to look it up, you could Google or search whatever you want to do, EFRIS and EU, so EU for European Union and EFRIS for European Fundamental Rights Information System, EFRIS, and it should pop up. So we call it a bit of the human rights gateway. It's a tool that intends to facilitate for the European Union's member states to remember the international human rights obligations and the monitoring mechanisms and the recommendations that or decisions that flow from these. So it's an attempt to, again, reduce the complexity, to remind the European Union, which sometimes forgets about human rights, that there is the international human rights law system out there. And for that reason, we collaborated with, and we still do, or my colleagues in Vienna still do, with the United Nations and with the Council of Europe, bringing together these two systems into a new interface that is adjusted, adapted, and developed for the European Union. So we use this relatively modern technology to facilitate this. So everything or most of the things in that tool is brought there automatically from the Human Rights Index and from the Council of Europe databases. And they are also now planning to add to that European Union's own mechanism, so the Court of Justice of the European Union and other relevant sources. It offers an overview in many ways, but also provides visualizations and a bit of comparative analysis, sort of average assessment of the EU member states, and you can see how your member state, if you're from one, compares to the average. It provides for easy access to the original sources. So if you click your way through, you'll get to the UDoc database or to the URI database and the actual source. So we're not duplicating or stealing the material. We're guiding the users to the original sources. We also provide comparison over time between countries, so you can see how things progress. And we offer, as I said, a bit of straightforward analysis where it's objective. So we're not adding any subjective element, but trying to offer using the objective assessments that have been done by the various monitoring mechanisms, for instance. To a few examples, and then I move on. You can select torture, for instance, in a drop-down menu and see the number of 44 thematic special procedures being reduced to the relevant ones for torture. You can look at graphs on the number of complaints to the UN treaty bodies by member state on a particular topic or across all topics. And finally, you could look at number of judgments by the European Court of Human Rights per capita and country related to a certain right, if that's what you're interested in. And then you'll get to the actual jurisprudence that the judgment is based on. So that was the EFRIS, so the European Union Fundamental Rights Information System. So worth a search on your device. I can see Adrian is searching for it to see the updates. My second point of the three on crowdsourcing. So civil society, of course, as we've heard today and throughout, I guess, history has been involved in various ways in monitoring human rights through shadow reports, etc. Increasingly, such actors also provide monitoring tools and analysis that compete with those of the intergovernmental organizations. I think crowdsourcing, drawing on as far as possible on non-intergovernmental organizations is very, very helpful, something that Peggy also mentioned. I think this is helpful in many ways. Credibility was mentioned. Of course, getting the work done is another important aspect. this could be done in addition to the examples that have been given already this morning through video documentation of police operations or tracking of boats and migrants crossing seas, or breaking down analysis of massive amounts of data into small manageable packages. I learned the other day about an interesting parallel example in what is called the Borderlands science. It's a mini video game that while playing this video game, you contribute to depackaging or unpackaging of a DNA code that computers struggle to do automatically. So you need a manual or human input. And by playing this little game, you contribute, every time you play it, you contribute to unpack the DNA code of some sort. I cannot go into any details because I don't understand the details. But I think things like that, sort of gamification of some sort, is helpful to engage people, but also to make pastime entertainment on your phone while waiting for the bus, also contributing to a greater cause. My third point, on the greater usage of non-human rights specific IT tools, I wanted to stress a few points also here. How human rights monitoring mechanisms can use IT tools that are not specific to human rights, that are not designed for that. And here I'm drawing a little bit on my not so extensive, but since the last few months, experience in the law enforcement sector, where I work with monitoring law enforcement, uniform law enforcement. And I'm thinking of tools that, for instance, United Nations has been using in the Global Pulse, where they are testing aerial assessment of wealth by analyzing the roof of dwellings, roof material of dwellings, comparing straw and corrugated steel, for example, but also tools such as those that were mentioned by Peggy. And I'm thinking of video authentication to ensure objectivity of evidence. I think of aerial surveillance for location of vessels and various other forms of location tracking for in terms of rights holders and duty bearers. So those tools should not only be used for one side, but both sides of the coin, as was mentioned. And greater use of body cams and various situations where cameras can be used to show and prove that things have happened or not have happened, to boost the credibility of various actors. And I think finally, as a vision, not something I have at my disposal in my new job, but augmented reality is used increasingly in military context to guide the soldiers. And of course, that will be, I guess, if not already, also used by law enforcement in various contexts, but it should also be used for human rights guidance to law enforcement and for human rights monitors to guide effective monitoring of law enforcement. So maybe if I am invited back in 5 years or so, maybe I can brag about some tool that we have developed with augmented reality. So that was basically what I wanted to say. I've highlighted three things: the interoperability and in the way that the European Union Fundamental Rights Information System, EFRIS, contributes to bringing systems together, I think in a very helpful way. I talked about crowdsourcing, about the gamification of data collection and analysis. And thirdly, about the use of general tools that should not only be used for potentially oppressive purposes, but also for doing the right thing. So with that, Dash, thank you very much.
Thank you, Jonas. And three very relevant points there. And on the first point about interoperability, in Samoa, what we saw when they installed Sedata, which is their version of Impact OSS, is that very point. When they had, I think initially they had around 700 recommendations and obligations, which is quite daunting for a small island state. But when we were able to use the technology, they put in their implementing actions that they were planning to do that were already in their national plans. So this wasn't creating anything new. And what they found was that those implementing actions, and there were only about 70 initially, addressed or partially addressed about 450 out of those 700, which demonstrated how much overlap there is between all of those mechanisms. So thank you so much for that intervention, and hopefully there'll be some questions for you as well. So that's the end of our panel, and we're about to move into the question and answer part of the session. So please feel free to raise any questions in the chat box and think about any questions in the room. Just before I open up the floor, I would like to introduce one of our participants today. We've heard from national mechanisms from that space, we've heard from the UN space in general, but we haven't heard in this panel from the national human rights institutions perspective. And today we're really, it's great to have Friedhelm with us, who is the executive director of Huridoct. And Huridoct have been working, one of their flagship tools is Uwazi, and they have recently been adapting Uwazi so that it can become an information management system for national human rights institutions, predominantly in Africa, but we've also been working with Huridoct in the Pacific as well. So before we start the Q&A, if it's okay, I'd just like to ask Friedhelm just to give us a quick introduction to what Uwazi does for national human rights institutions, and maybe just some insights into if people are thinking about what tools they can look at, and this speaks to Jonas's point. Should they look at off-the-shelf solutions that are already there, or should they look at bespoke developments, and what considerations should they take into account? Over to you. Thank you, Friedhelm.
Thank you, Ash, and thank you to the panel and to Geneva Academy for organizing and very stimulating contributions. Just a couple of points, I think, on your question, whether there should be off-the-shelf solutions or adapted solutions. I think for national human rights institutions, it's critical to have solutions adapted to their needs, and that these needs are deeply understood. Because while there are commonalities across institutions, every institution has its own mandate, its own quirks, its own needs, and its own possibilities as well in terms of capacity. So if we speak about the Fiji Human Rights and Anti-Discrimination Commission, which has just over 10 staff, or we talk about the Philippines Commission on Human Rights, which has more than 700 staff, it's quite obvious that the needs and possibilities will be different just by virtue of having a 70-fold difference in staff membership. And it's worth really focusing first and foremost on understanding those needs. And I really appreciate what Salman said, and focus it from a perspective of how to enhance agency, both for those, if a national human rights institution is primarily dealing with complaints, the needs of the complainants, to just understand, where is my complaint? Has my complaint been responded to? At what stage is it at? So to understand, not just for, okay, we don't want to be late with reporting, but really to start, okay, where do we start from? We start with a complainant that we need to respond to. So hopefully we can help them achieve a response to their complaint, ideally some sort of redress. The needs of the complaint management officer. Are they overwhelmed with complaints? Will introducing technology help with that, or will it further complicate their work? And understand really how can it help or ideally facilitate that. Then the next level of the person who will probably look at this and analyze, okay, we're consistently late with responding to complaints. What can we do? What can we structurally do? So to understand that level, and then maybe first, not the first entry point, but the final point is then, how does this correspond to our need for reporting to recommendations? Because it's really worth looking at the whole chain and understanding the needs in the whole chain, not sort of jumping in with, I think has been said many times, a technology solution will sort of magically solve that. It's really about understanding the different parts of the workflow, where can technology come into aid or present new barriers of access, new barriers of just time required. And then I think it's important to understand, okay, where are we? Where do we need to focus on? And then I think as a general point, it's never a good idea to focus on bespoke solutions, because while needs may be unique, bespoke solutions will need incredible maintenance, will need incredible upkeep, and it's very difficult for institutions just to deliver that. And then the question is, how far off the shelf do you want to go? And that's where I think the understanding of needs comes in. And ideally, there's some way of a flexibility to adapt to the languages an institution uses, to the different parts of the mandate that might need to be included. No one would think of creating an accounting system from scratch, for sure, but if it's a complaint management workflow, that might be something where you need to put additional focus on. So maybe I'll stop here, focus on the needs, avoid bespoke, and then once you've understood your needs, see what level of flexibility you need. And maybe just to re-emphasize on Peggy's point, to take a human rights perspective into all of this. So as you're making choices there, to also look at with the vendors you're interacting with, to what extent they may or may not be compliant with human rights themselves.
Thank you. Thanks so much, Friedhelm. And I think as well as giving us a really good insight into Uwazi and the bespoke versus off the shelf, I think inadvertently what you've done is highlight one of the key features in my experience of a successful development of a tool, which is the need for a combination of human rights expertise or technical substantive knowledge expertise plus the development knowledge as well. And that's a very hard balance to find. Often you get more of one than the other and it causes problems. And from my experience working with Horidocs, they've got that blend really nicely down. And as a result, the tool that they've developed for the Fiji Human Rights Commission, soon to be implemented by the Samoan Ombudsman's Office, and I know by a lot of African NHRIs, has real value to it. And the value that it brings is around public credibility, because it enables them to collect their data in a way that ensures its validity. It enables them to carry out effective monitoring and analysis of violations that just wouldn't be possible on paper. We know with our experience with the Fiji Commission, they had reams and reams of cases going back years that was just totally unmanageable. That's now a thing of the past. And going back to Seema Samar's point this morning as well, it's about retaining institutional knowledge, and their experience right now is just the most extreme example of that. Having a good information management system helps protect against situations such as the one that they're currently facing right now as well. So thank you so much for the intervention, Friedhelm. I really appreciate it. Okay, so over to the floor. I think we have Vincent Ploton from the International Service for Human Rights who would like to make an intervention online. But if I could ask anyone in the room as well to also raise a hand if you would like to ask any questions, now is the time. Okay, so we've got 2 questions over here, and then maybe over to Vincent. And please feel free to put your hand as well.
Thanks. Ash, I was really struck by what you said at the start, which is that the private sector is leading in this. And so coming from a private sector law firm investigations background, I kind of racked my brain to think, are we I don't serve in that context anymore, but are we really streaks ahead? And one thing that really struck me is the use of blockchain technology, which is being used by private law firms and large companies for years now to collect evidence for investigations in a way that authenticates it and gives it credibility to then be used in litigation before domestic tribunals or international arbitration tribunals. And I guess my question is for Peggy and Jonas, mainly because you spoke on this, is what is being collaborated with the private sector? I saw an article this week about whether Facebook and Twitter need a seat at the table at the United Nations. Maybe that's going too far, but what is being done to collaborate with the private sector so we can take some of those learnings and incorporate it into what we do here in the human rights context?
Thank you. I think there's a gentleman next to you.
Yeah, thank you for your excellent presentations. So we have witnessed spawning of commissions of inquiries and other investigative mechanisms which use remote monitoring when countries do not allow access to these experts. So my question is, when these remote monitorings happen, especially in a 2018 OHCHR report, we witnessed that countries were vehemently against the methodologies adopted in the process of this kind of remote monitoring. So what is the legitimacy gap that can be addressed by national and international human rights actors, especially since these kind of monitoring mechanisms can help facilitate future litigations, both at tribunal level or at the International Court of Justice. Yet, if we witness some kind of legitimacy gap, that might have impact. So what are your thoughts on some of these issues? Thank you.
Thank you. And we'll just go online to take the question from Vincent, and then we'll hand over to the panel. Vincent, are you there? Welcome. Good morning.
Good morning, good afternoon to all. Thanks very much. Thanks to the organizers and the moderator and the panelists for a really excellent presentation on such a key topic. My focus was going to be on the treaty bodies, and I would have a question for Peggy, although I understand that Peggy doesn't have direct responsibility for the treaty bodies. We've had a review of the treaty body system in preparation of 2020, as part of which Geneva Academy coordinated a number of very valuable inputs. And one of the topics about which a number of actors have contributed is the digital shift. There were contributions from states, from civil society, from the treaty body members, from the OHCHR as well. There was a very widespread recognition of the potential benefits of a digital shift in the work of the treaty bodies, and the fact that the treaty bodies are very much lagging behind in terms of taking that digital shift. This has been illustrated, for example, with the notorious situation of the processing of individual communications, individual complaints, which still is very archaic and would very much benefit in a better digitalization, a use of a better technological tool. So the welcome news is that perhaps because of this very widespread recognition of the potential benefits and the need to move towards a digital shift, the follow-up to the 2020 review focuses on 3 topics, one of which is the digital shift, the other ones being the adoption of fixed and predictable review cycles and the harmonization of working methods. We understand there's a proposal which is public by the chair of treaty body chairpersons, the CRPD chair, with details on what the digital shift for treaty bodies could look like. And we understand there's a process ongoing as we speak within the OHCHR on taking that digital shift. So again, bearing in mind the very vast potential for the treaty bodies and for the users, both state and non-state users of the treaty bodies, it'd be fantastic to hear a little bit from the OHCHR in terms of where the process is at with implementation of the digital shift inside the House. Thank you.
Thanks, Vincent, and thank you for also pointing out it's no longer the morning. I'm obviously slightly behind the times. Okay, so we're going to hand over these 3 questions to our panelists, and again, I'll do it in reverse order if that's okay. So I'd like to invite Jonas, if you'd like to respond to any or all of the questions, and if we could again keep it to around 2 or 3 minutes. Thank you.
Thank you. I like to be first because then I can say the bland things, and then the others can come with the clever remarks. So I'll just I'm the warm up. From my current perspective, I work in the law enforcement industry in some ways. I think the cooperation there is quite extensive with industry, with development. So the technological developments there is very much driven by the private industry. And I guess it's my job to make sure that technology is at least not abused, but ideally used for the right purpose. So I spend some time, and my colleagues, for instance, checking how we use the usage of drones, airplanes, monitoring, etc., as an example of technology and human rights monitoring. When it comes to the EU as a whole, I guess you're well aware on human rights. I think there's maybe not so much driving force from the private side, even though the European Union engages with actors like Microsoft and Facebook on takedown practices in relation to hate crime and security issues, in relation to the environment, very much lately. But I think there would definitely be much more that could be done from a human rights perspective. I struggle a bit finding examples. And on the legitimacy question, I don't think I have anything useful to say other than in my current job, where I have to show that I'm independent, that I'm credible. In that context, legitimacy is very important to have impact, to ensure that what I say, what I advise, that it has traction and impact. And it's something I struggle with every day. And a few months into my current job, I still need to learn a lot and improve a lot. So just grateful for the question, which was not specifically on what I spoke to, but in general, the legitimacy issue. Thank you.
Thank you, Jonas. And Salman, if you're still online, could we pass over to you, please, for any responses you would like to make?
Yes, I would like to particularly thank, with regards to the reflection on the business and the private sector. This was an area that we began to look at, and we began to have discussions with the stakeholders, and particularly with the government stakeholders, chambers of commerce, entrepreneurs, so on and so forth. And we were very keen that the inclusion of the business sector, of the private sector, should be an integral part of the larger human rights framework in Pakistan. And that led us to have further discussions, for example, with the Ministry of Commerce and Ministry of Human Rights, and to really advocate for the Federal Ministry of Human Rights enshrining the private sector and the business sector within the human rights framework. And that has, in the last year and a half, led to development of the National Action Plan on Human Rights in Pakistan that has been passed by an act of parliament through the cabinet. And the National Action Plan on business and human rights in Pakistan is really led, guided, enshrined within the UN guiding principles on business and human rights. So with that act of parliament, if you like, and support from the private sector itself, it seems that a bridge has been gapped. A gap has been bridged. So, and that we hope would lead to impact within the private sector, within the business sector. Of course, there is a tradition amongst the larger businesses and within the private sector of the social corporate responsibility. But to bring that within a national framework required a series of consultations, negotiations, navigating various positions, and some of the positions may be very hard to influence or to bring about a shift. The outcome, as I pointed out, has been one which is positive and hopefully lasting with the National Action Plan on business and human rights in Pakistan, and it's kind of becoming part of the larger human rights framework within Pakistan, which is the Action Plan on Human Rights. Thank you.
Thank you very much, Sam. And if I could also hand over to Alejandra, please, the floor is yours.
Ashley, thank you. You know what, for time's sake, I think it would be better if Peggy has her time to answer, because many of the questions actually were more directed to her than whatever I can say. It would be more interesting to listen to her, right?
I hope I can live up to that confidence, Alejandra.
I know you can.
No, appreciate all three questions, and then all three probably could be the subject of much longer conversations. I'm going to take them in reverse order. And thanks, Vincent, for the emphasis on the review of the treaty bodies and the outcomes. I am familiar with the digital transformation piece of that, not as much with the other pieces, but on the digital transformation piece, I think the good news is either through that process or through the general recognition of the need for this, it's absolutely the case that this is an overarching priority for the office currently. There is, we hope, a real interest amongst donors to support that sort of upgrading of the way in which the treaty bodies work and to bring digital tools to bear more effectively within it. The only thing I would emphasize, because I think this is an audience that would really understand this, is that one of the things that we're looking at institutionally is the difficulties in doing these things in a piecemeal way. The treaty bodies, as we've talked about today, are connected to all the other human rights mechanisms, the special procedures, the work of the office itself, the UPR. And if we start creating, and this goes to Freedom's point earlier, separate systems, that this is the platform that the treaty bodies are using, and this is what special procedure, you can very quickly see the fact that we also need to look at these things holistically and to have integrated approaches across the systems that we use to be able to be as effective as possible. That, of course, cannot in any way delay the urgent need to upgrade some of the elements of the treaty body practices. So we're trying to do both things at once and to get states and others to come in on that, which I think actually means I'll flip to the question about business next, because I think it's a really important question and very interesting, and my answer isn't going to be very satisfactory. I support everything that Salman said about the UN guiding principles for business and human rights and the work that can be done in that sphere. We have a whole big project on that many of you are familiar with called BTEC, which is about how we operationalize really the guiding principles within the tech sphere. And we do have really, substantive ongoing conversations with tech companies on some of the real challenges about, what does mitigation and remedy look like in a tech context. But I think your question also really pointed to something different, which is how are we learning from private companies, law firms, the tech sector and others about how we can deploy what they're already using and could be used in the human rights side. And I have to say, I don't think we've gone nearly far enough in that regard. I think that, your comments about blockchain were really interested. And I know that our investigative unit is looking at things, but I think there's probably lots that we could learn there and do more on. But it takes me back to that point about, trying to do both of the things on treaty bodies. These ultimately come down to resources and investment in a lot of things. And the reality is, and I'm sure this is not something that's unique to the UN Human Rights Office, this is not where the investment is within the way that the UN budgetary process currently works. And I think that the more that we can do to get out the word about how investment in these areas can actually not only make us better at our jobs, it can ultimately probably deliver better results for less money down the line. It's not that easy within current resources to take on some of these bigger projects and to capitalize on expertise outside of the office in the way that the question pointed to. And I'd love for us to be able to do more. And then the final question, and a really interesting one about the remote monitoring and legitimacy. I wanted to focus sort of on 3 points in responding to it. The first is, I think you have to recognize the process that takes us to use remote monitoring. And the reality is, it is not the first step. We use remote monitoring when we are not able to deploy other tools, but we also, don't want to have human rights blind spots simply because we're not able to get into a place and do on the ground work. I mean, that would be the worst scenario, right? So we need to use remote monitoring. It's a critical element of our toolbox, and we use it, with a lot of safeguards in place to make sure that we have confidence in the credibility of the investigations that we do in that basis. But I take your point, meaning that, of course, even if we believe in it, unless people have been on the ground, there's always going to be an answer that, it's not as good as what could have been achieved by actors on the ground. And, obviously a very valid observation there. And that leads to the last point I wanted to make, is that I want to emphasize that even when we're not ourselves on the ground, we do, do everything possible to work with local actors within the concerns of protection of those actors and their safety, to make sure to not only rely on them for the information that we use, obviously, but also to validate the findings in a variety of ways. And I think the more that we can learn from and integrate those sources in different ways, the more credible the investigation will be. And obviously, as Freedom's comment pointed to earlier, there are institutions in each country context with differing levels of credibility themselves from a human rights perspective. So we do, there are instances where perhaps the government institution doesn't have a high degree of trust and credibility on the human rights side, but there are national NGOs or other actors who do have that role. So, really looking at that full range of on the ground actors and trying to make sure to engage with them and make sure our results and our work is fully grounded in the reality they see on a day-to-day basis is a critical element when we do remote monitoring as well. Thanks.
Thanks so much, Peggy, and thank you to all of our panelists. And that really brings us to the conclusion of this plenary. There were a couple of questions that came in during the responses, and just to let you know that the Geneva Human Rights Platform will respond bilaterally to those so that no questions are left unanswered. And similarly, if anyone in the room has any further questions, we're very grateful to have lunch and the opportunity to engage further as well. So please don't be shy in coming up to speak to any of us that are still able to stick around for lunch. I'd like to take this opportunity to thank the partners of this plenary, obviously the Geneva Human Rights Platform for convening this event, but also the Paris Human Rights Centre, the United Nations Development Programme, the Office of the High Commissioner for Human Rights of the United Nations, HURIDOCS, of course, and the Geneva Internet Platform. I'd just like to finish on a small reflection. We've heard so much about the benefits of technology. Mohamed mentions and referenced the Samoa Convention on the Committee on the Rights of the Child session last year. This was the first time that any of the UN treaty bodies had held a regional session outside of Geneva or New York, so it was really historic. And the Pacific community was delighted to partner with the Office of the High Commissioner for Human Rights in delivering that. And what we saw there was bringing the treaty bodies closer to the rights holders just had an unbelievable impact in terms of engagement, ownership of implementation, follow-up, and it just empowered so many people. We had engagement with over 1,000 children, and the committee, and I was able to write the evaluation report, and the committee members said that nothing like that had ever been achieved in their history, and that was because it was all face-to-face. So the point I would like to make is, if you're looking to use digital tools or to set out on any sort of initiatives, going back to Peggy's point, think about the limitations. Sometimes there's no replacement for face-to-face engagement. There really isn't, and in our work it is just so important. So let's not take the humanity out of human rights, and I wish you all the best in your endeavours and look forward to working with you all. Thank you.